Hello everyone and welcome to today's Mondac webinar in association with Sam Okazetu and Associates, who will be discussing arbitration in Ghana, featuring the best practices and latest developments. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Nene Emagacha is a senior partner at Sam Okazetu and Associates and a retired justice of the Supreme Court in Ghana. He has over 3 decades of experience in private legal practice and academia. He is an expert in civil litigation, corporate and commercial law, and alternative dispute resolution. He is a former president of the Ghana Bar Association and has served as the Ghana representative of the ICC Court of Arbitration. Melissa Amatefio is a partner at the firm. Her areas of focus are civil litigation, property law, tax law, commercial law, alternative dispute resolution, and intellectual property. Melissa has significant experience in arbitration and has acted as counsel representing a rubber production company in a multi-million euro arbitration where she successfully secured an arbitral award in favor of her client. Finally, Isaac Abraham Latte is a senior associate at the firm where he focuses on litigation and dispute resolution. He has experience in property, employment and commercial disputes, particularly in the manufacturing, real estate and construction sectors. Isaac has acted as counsel for clients in commercial disputes and the Ghana Arbitration Centre. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to the panel to begin. Thank you.
Right, thank you very much, Dan, and welcome everybody. Melissa and Nene, it's very good to have you here today for this discussion. We are going to be talking about arbitration in Ghana, keeping up with key international best practices and developments. So I'll start off with Justice Amegache. You have had the privilege of practicing in the early 80s, where we had the Arbitration Act of 1961. You know, arbitration has definitely come a long way, and we want you to give us your view of the nature of the legal framework that existed at the time prior to the enactment of the ADR Act currently.
Yeah, thank you, Isaac. Arbitration in Ghana, as you said rightly, was governed by the Arbitration Act of 1961, Act 38. And prior to the enactment of that act, we had an arbitration ordinance, which was at the back burner, but Ghanaians were more deeply into customary arbitration, where Ghanaians went to their chiefs, their family elders, and resolved disputes under customary law. Now, even though the Arbitration Act of 1961, Act 38, had long been in existence, I can tell you that the practice of arbitration for the resolution of complex commercial disputes was not in vogue during the years of my practice. And I could assign the reason of the low patronage to arbitration at that time, first to ignorance on the part of parties that they had that alternative to resolving that dispute. Secondly, lawyers and judges were not trained in the concept of arbitration at that time. There were few contracts that had arbitration clauses, and so there were few cases that came before the courts to interpret some of these particular provisions. This was coupled with the existence of not too many lawyers. At that time, we had few lawyers. All of them were trained in Britain, and the training did not include arbitration or alternative dispute resolution. The training was basically in the litigation, hardcore litigation. So I will say that because of that, arbitration did not fully develop at that time, and arbitration was also not taught at any of the law schools. Our law school started training people in 1963. That's when the first graduates came. The arbitration was not part of the curriculum. When I was at the law school, even up to 1980, arbitration was not part of the curriculum until about 2010, when I introduced it as part of the advocacy lectures. Another problem also was that there was no arbitral institution. There was no institution that one could identify and go and say, this is an arbitral institution where arbitration could be conducted. So basically, arbitration was unknown in the country, although statutorily there was a legislative backing for that purpose. So in a nutshell, even though Ghana had a legal framework for arbitration as far back as 1961, the practice of arbitration at that time was not popular at all. So that would be my introductory remarks so far as Act 38 was concerned.
Well, thank you very much, Justice Amegache, for your thoughts on the nature of the legal landscape on arbitration in the early 60s through to the 80s when you were a practitioner. Now, you talk about the fact that there was the existence of the framework of arbitration, which was the Arbitration Act of 1961. Were there any particular challenges with the legal framework at the time that called for a review of the legal framework?
Yes. I would say that the Arbitration Act of 1961 predated so many key international conventions and developments in arbitration. To start with, Ghana acceded to the New York Convention in 1968, approximately 7 years after the passage of the Arbitration Act, although the schedule to the act had the New York Convention in it, but it was not domesticated. Again, since the aim of the New York Convention was to provide globally uniform regime for the recognition and enforcement of arbitral awards and arbitration agreement, this called for a reconsideration of the arbitration framework of most countries, including that of Ghana as well, in order to take care of that. Then there was the problem of the UNCITRAL Model Law. The UNCITRAL Model Law was published in 1985. And if our Arbitration Act came into force in 1961, then you could say definitely that there was no consideration of the UNCITRAL Model Law on commercial arbitration. And therefore, Act 38 did not consider or did not factor in any of the internationally accepted procedures for commercial litigation in it. Act 38 also did not provide for certain key provisions which you should have in any good arbitration law for arbitration to function. One example that I'll give you is the concept of separability of the arbitration agreement from the clause. That was absent from Act 38. Act 38 was also fraught with various instances of interferences from the court. When you look at various provisions of the Act, it opened up the arbitration to unnecessary intrusion by the High Court, making it unattractive. And if you're going to have the courts interfering in arbitration, then why not go to court straight away and have your dispute resolved by arbitration? So by the turn of the millennium, it was apparent that Ghana did not have the appropriate legal framework. Although the law was there, it was not up to international standard for people to use the services of arbitration. At that time also, the World Bank had come to Ghana and was doing a study about the legal system of Ghana and whether the legal system of Ghana was responsive to the needs of commerce and industry. And the report from the World Bank that came was that for industry to thrive and for investment to thrive in the country, then the legal system must be brought in line. And so discussions started from the Attorney General's Department with a view to passing a new legal regime that will take into consideration the UNCITRAL Model Law and other key provisions that will make arbitration attractive. It is these discussions that led to the passage of the Ghana Alternative Dispute Resolution Act of 2010, Act 798. And I think it will be appropriate at this time to invite my colleague and partner, Melissa Amatefu, to walk us through some of the few highlights of the acts that was passed in 2010. So, Melissa, let me pose this question to you. In the wake of the challenges with the previous legal regime, and I mean Act 38, and the passage of the ADR Act of 2010, Act 798, what are your thoughts about some of the key features of the new act that you would say had modernized the legal regime on arbitration in the country?
Thank you very much, Justice Amegache. As you've rightly pointed out, arbitration in Ghana is governed by the ADR Act, and the Act is predominantly fashioned around the UNCITRAL Model Law on international commercial arbitration. However, there are few exceptions. The Act was not a carbon copy of the UNCITRAL Model Law. With regards to key features of the Act, the first thing you notice is that the Act recognizes and upholds the concept of party autonomy throughout the process of arbitration. Parties are firstly free to refer their dispute to arbitration by means of a written agreement. And when this agreement comes into force, the parties are also free to decide on the nature of the arbitrators that they would appoint, their experience, their qualifications, their nationality, even the number or the process of the appointment of such arbitrators. The tribunal is also required under the Act to decide on cases based on the substantive law that the parties have chosen. In addition, in collaboration with the tribunal, the parties are given the right to decide on the procedural rules that they want to govern the arbitration. So that is one key feature of the Act. Another key feature of the Act is the concept of separability. This concept is that there's the separation of the arbitration agreement from the substantive contract. This was not previously provided under the old legislation like you have indicated. What happens in such cases is that if there are certain portions of the substantive contract that are deemed to be invalid or void or illegal, the arbitration agreement still survives, and a dispute arising out of that contract can be referred to arbitration. The Act also recognizes the competence of arbitral tribunals to determine their own jurisdiction, and this is known as the concept of competence. Interestingly enough, the Act also allows or permits the High Court to determine an application based on the jurisdiction of the tribunal. I'll talk about this much later in the presentation. The last key feature of the Act, which I'll talk about, is the recognition and enforcement of foreign arbitral awards. So the Act allows Ghana as a jurisdiction to enforce foreign arbitral awards insofar as Ghana has a reciprocal agreement with the country where the award emanates from, or if that country is a contracting party to the UN, to the New York Convention.
Thank you, Melissa. There was an issue that I'm very much interested in. You referred to the Alternative Dispute Resolution Act, and then you kept on referring to arbitration. I'm aware that the Nigerians have an arbitration and mediation act specifically. You go to the UK, the act there is the Arbitration Act. So how can you have the phrase alternative dispute resolution and then you start talking about arbitration? I know there are quite a number of jurisdictions where arbitration is not recognized as an alternative dispute resolution. So what is the basis of that description?
Yes, Your Lordship, Justice Amegache. There are actually two schools of thought when it comes to the definition of alternative dispute resolution. I am aware that in the UK, arbitration is not included in the definition of alternative dispute resolution, but then in America it is. This case is the same in Ghana, where Section 135 of the ADR Act describes or defines alternative dispute resolution as the collective description of methods of resolving disputes otherwise than through the normal trial process. So if there's any means of resolving a dispute otherwise than through the courts, it falls under the ambit of alternative dispute resolution. So arbitration is definitely a part of alternative dispute resolution under Ghanaian law.
Thank you. Okay, that's quite so. In Ghana, arbitration is part of alternative dispute resolution. Now, we are in 2023, which means that the ADR Act has been in existence for 13 years now. Now, how do you see the landscape of arbitration? Do you think that there is any increase in awareness of arbitration among the key stakeholders in this country?
Thank you very much, Justice Amegache. Arbitration has grown in leaps and bounds in Ghana since the enactment of the Act. In fact, in the early 2000s, there was an influx of foreign direct investment in Ghana in several industries spanning across mining, construction, infrastructure, and banking. And what we'll see is that most of these industries now adopt arbitration as the preferred mode or mechanism of resolving their disputes. That being said, though, when it comes to arbitration centers, we notice there has not been that much growth in Ghana. For the longest while, the Ghana Arbitration Center, which was established in 1996, was the key player as the main arbitral institution in Ghana prior to the institution of the Ghana ADR Hub in 2018. I've looked at the arbitrators on the membership of the Ghana ADR Hub, and there are quite a progressive number of arbitrators on there. So we hope that with the expansion and development of arbitration in Ghana, there will be more arbitral institutions setting up to determine disputes. We also note that there's been a greater awareness in arbitration by practitioners in Ghana. The ICC has a committee on ADR that regularly organizes conferences and training on arbitration. I know that the Chartered Institute of Arbitration also recently opened up a chapter in Ghana that is organizing training to increase the knowledge and skills and awareness of arbitration practice in Ghana.
Quite interesting, quite interesting. So one of the areas of concern in arbitration legislation is the need to strike a balance between the role of the courts in facilitating the arbitral process and preventing an excessive intrusion of the process by the courts. Parties always prefer an arbitration framework with minimal court intervention in the process. Now, what I want to find out from you is that what is the scope of the court's facilitative role in arbitration under this 2010 ADR Act of Ghana?
Okay, so the Act allows the courts to interfere, or as it describes it, support arbitral proceedings through various means. One of the ways in which the court supports arbitral proceedings is by staying proceedings in the court where a dispute has been brought before it, where the subject matter of the disputes originates from an agreement that has an arbitration clause. In such instances, you find the court staying proceedings on an application by either party and referring the matter to arbitration. Interestingly enough, even where there's a dispute without an arbitration clause, the court is sanctioned under the Act, where in their view, the court believes that the dispute could be resolved by arbitration, to request the parties to resolve these disputes by arbitration or any other means of alternative dispute resolution, The courts can request the parties to do so, and if the parties do agree in writing, the courts can stay proceedings and refer the matter to arbitration. So that's one way in which the courts can support arbitral proceedings. Another way in which the court supports arbitral proceedings is that it can determine an application to challenge the appointment of a sole arbitrator, can determine applications for the removal of arbitrators. It can also determine the entitlements and fees or expenses of an arbitrator or a tribunal. The court also has powers to determine the liabilities of the arbitrators or the arbitral tribunal. Another way in which the court can support arbitral proceedings is that it's given the right to determine the jurisdiction of the tribunal and make orders relating to evidence, property and goods, granting an interim injunction, and appointing a receiver, or to determine a preliminary point of law.
Yes, from what you have just said, you've talked about facilitative or supportive role of the court and then unnecessary intrusion on the part of the court. Scanning through the ADR Act, would you say that the court's role is more supportive than intrusion or more intrusive than supportive, or there's a balance?
I think there's two schools of thought here. There are some practitioners who believe that the court's role is more intrusive than supportive. And personally, I think in my practice, I haven't encountered a court intruding so much during the arbitral process. But then because of the wide powers that the Act gives the court to support arbitral proceedings, there's a likelihood that it could result in intrusion of the arbitral proceedings.
So with that in mind, is there any areas you think this ADR Act could be improved in order to balance the court's control over arbitral process? Because we have already said that parties generally will not go in for arbitration where there are unnecessary intrusion on the part of the court. So do you think there are areas that ought to be looked at again?
Yes, Justice Amegache. I've scanned through the Act and I believe there are several areas which require improvement or some second look at. For the purpose of this webinar and because of time constraints, I'll limit myself to two topical areas under the Act. The first is the determination of the jurisdiction of the tribunal. Like I indicated earlier, the Act introduced the concept of competence, where a tribunal has the powers to determine its own jurisdiction. However, in the same vein, the Act also allows a party to apply to the High Court, where a tribunal has determined its own jurisdiction. Ordinarily, it would seem that this extra layer of check on the tribunal's determination is a good thing, but then it can result in abuse, or it can be used by a party who intends to frustrate or delay the arbitral process. When you look at the way in which that particular section is couched in the ADR Act, it's quite lax in that a party who believes that the determination of the tribunal's own jurisdiction was in error can apply to the High Court or notice to the other party, and as long as the application is done within 7 days after the ruling. In other jurisdictions like England, there are quite stringent limitations put on the right of a party to bring such an application before the court. Under Section 32(2) of the English Arbitration Act, and this is what it says, I will read it quickly. A court shall not entertain an application for the determination of the tribunal's jurisdiction unless it is made with the agreement of all the parties to the proceedings, or if it is made with the permission of the tribunal, and the court is satisfied that the determination is likely to produce substantial savings in cost, the application is made without delay, and that there's good reason why the matter should be determined by the courts. I mean, these rigid grounds that have been provided under the English Arbitration Act would result in a situation where there would not be too much interference of the courts in the determination of the tribunal's jurisdiction. It also accords with the principle of party autonomy, and it reinforces the party's choice in settling their disputes by arbitration. On a more compelling note, and something that we should consider or probably debate more, is that at the point where an arbitral award has been given, and the judgment creditor or the victorious party seeks to enforce it in courts, the courts can also determine an application of jurisdiction at that stage. So there's some school of thought that thinks that if this opportunity has been given to a judgment creditor, it probably should be taken advantage of at the point where you're enforcing an award, instead of during the arbitral process, which could result in too much delay and undue interference. So that's one area that we have to consider. Another area that we also have to consider is the preliminary points of law determination. So you'll find that Section 40 of the Act permits the High Court to determine any question of law that arises during proceedings upon an application by a party or notice to the other party. And the criteria is that as long as the court is satisfied that the question substantially affects the rights of the other party, then such an application can be brought. And even after this application is brought to the High Court and is determined, there's a second tier or a second bite at the cherry where that party can appeal on such points of law determination once the High Court grants its leave. So the concept of this preliminary points of law determination risks the tendency of excessive applications to the High Court, given the relatively low threshold under the Act for bringing such an application. In my personal opinion, parties in an arbitration generally adopt arbitration with a view to having the tribunal settle all their matters, be it legal or factual. So the minimum threshold of the determination of a preliminary point of law under the Act, which allows the court to determine any question of law that arises in the course of proceedings, in my view, may substantially affect the rights of the other party in a dispute, because, like I said, there will be undue delay, undue interference if that party wants to intentionally frustrate the process. In any case, I'm of the opinion that almost all legal issues in a dispute, which is before an arbitral tribunal, have the tendency to affect the rights of the parties to the dispute in one way or the other. So this could be relied on as a basis to invite the court to determine any legal issue. There have been instances where parties have taken advantage of this particular section of the Act to delay the arbitral proceedings. I'm sure you are very well aware of this because I'm coming to reference a case where you sat as sole arbitrator. So there's this case in the High Court entitled Republic versus High Court Commercial Division, Accra, ex parte Gassem, where the tribunal, constituted by Nene Amegache yourself, sitting as sole arbitrator, had refused an application for joinder of a non-signatory to the arbitration agreement. The non-signatory to the arbitration agreement was the parent company of one of the parties to the suit. And the application by the applicants was brought because the applicant was of the opinion that the parent company needed to be part of proceedings for the effectual determination of the suit, even though that parent company was not a signatory to the arbitration agreement. You dismissed the application for joinder, and the party who was dissatisfied with your ruling applied to the High Court to determine this issue as a preliminary point of law. The High Court then assumed jurisdiction and made an order for judgment, because in the High Court's opinion, an application for joinder can be granted where a party is necessary for the effectual determination of the suit. So even though the party was a non-signatory to the arbitration agreement, the High Court believed that this was the point of law it could determine based on the High Court civil procedure rules, which, as we know, have no bearing on the arbitral process, especially in light of party autonomy. After the High Court gave that decision, the dissatisfied party then applied to the Supreme Court for an order of certiorari to quash the High Court's decision. And Justice Doche had an interesting ruling, which I would read. This is what Justice Doche said. He said, what happened before the sole arbitrator, which ended up in the High Court, to our mind, was not a determination of a question of law in the course of arbitral proceedings. What must be noted is that the provisions in Act 798 on arbitral proceedings must be considered as alternative methods of resolution of disputes. And therefore, in our view, the intervention of the High Court, unless expressly provided for, and in clear instances devoid of any controversy, must be very slow and cautious. Otherwise, in our respective opinion, the High Courts will once again use these interventions to whittle away the functions of the arbitral tribunals and render nugatory the benefits that are to be derived from these arbitral proceedings as contained for and provided for in the Alternative Dispute Resolution Act. So in my opinion, the High Court's unwarranted intervention in the arbitral process in the GASEM case was made possible due to the minimum threshold of the application of a determination of a preliminary point of law. Other jurisdictions we've noticed have more stringent conditions attached to an application being brought by a party to the court to determine a preliminary point of law. For instance, under Section 45 of the English Arbitration Act, an application for the determination of a preliminary point of law will not be considered unless it falls within the following grounds. First, it must be made with the agreement of all the other parties to the proceedings, or it must be made with the permission of the tribunal, and then the court must be satisfied that the determination of the question is likely to produce substantial savings in cost and that the application was made without delay. I think that this is a portion of the act that we have to take a second look at in a bid to respect party autonomy and allow the arbitral process to move on efficiently. But I have a question for you, Justice Amegache. Considering you were the sole arbitrator in this matter, and considering you've also sat as a justice of the Supreme Court, what was your view on this GASEM case, specifically the certiorari application that was granted by the Supreme Court?
What answer are you expecting from me? I would say that I'm happy the Supreme Court confirmed the position I took earlier when I sat as a sole arbitrator, that the matter that was brought before me was not a question of law, it was a procedural matter and an attempt to interpret Section 40 of the Act by dragging a purely procedural matter and asking the High Court to interpret it as a question of law is one of the challenges which we have been talking about that parties could use in order to frustrate and drag arbitral proceedings. So I would say that I'm happy the Supreme Court agreed with the position I took. But before you are done with this issue about jurisdiction, these days arbitral tribunals are made up of very experienced arbitrators. Majority of them retired justices of the Supreme Courts and Court of Appeal and High Court. Some of them chief justices, having worked for over 30, 40 years and have experience in dealing with questions of law, sitting as arbitrators. Why should there be a provision asking a court constituted by a High Court judge who may just have few years of experience on the bench to come and interpret questions of law for an arbitral tribunal to follow? Well, why do you think Parliament inserted this provision of Section 40 in a way in which it was done?
I believe the rationale for this particular section was to provide an extra check or an extra layer of protection to parties in arbitral proceedings in the event where the arbitrator may not have the expertise to determine questions of law. Although I find that far-fetched, because most discerning parties would make sure they appoint arbitrators who are well-versed in the area, the subject matter of the dispute, or who have a good grasp of the substantive law procedural rules. Do you have any thoughts on that?
Well, I disagree with the power that is given to the High Court to intervene in such matters. My personal view is that once the tribunals are presided over by arbitrators with experience, even where they are non-lawyers, they are these days giving training and they have experience, I will prefer Section 45 of the English Arbitration, a qualification of the circumstances under which point of law could be determined by a court to the blanket given to the High Court of Ghana to just intervene in any matter. Any party could just apply to the court to determine a question of law. And the arbitral tribunal may be competent to determine what the question of law is. But a party who wants to frustrate the arbitration could say that there is a question of law in the matter. And basically, I'm sure that any dispute that is placed before an arbitral tribunal will invariably have a question of law. So it's about time to have a second look at this so that parties will not maneuver the procedure in order to frustrate arbitral tribunals in this country. So thank you, Melissa, for your answer. And I think it will be time now to move on and get Isaac's thoughts on some few international matters.
Thank you, Justice Amegache. So Isaac, globally, there has been significant developments and trends in arbitration since the passing of Act 798. These trends have seen arbitral institutions worldwide revising their rules and states reforming their legislation on arbitration to keep up with the arbitration landscape globally. As a young practitioner who is very interested in arbitration, what are some of the trends and developments you think are worth considering as far as reforms of the Ghana arbitration landscape is concerned?
Well, thank you very much, Melissa, for this question. Yes, like you rightly indicated, globally arbitration is evolving because arbitration is dynamic, and there are a few trends that we are seeing, one of which is third-party funding. Due to the fact that the economic value involved in arbitration disputes are very high, some parties are unable to fund, arbitrations against huge corporations due to the cost involved. So third-party funding has become an entrenched concept in international arbitration, allowing parties to access funds from funders who would take to pay the legal fees of parties, the arbitration fees, the fees of the tribunal, and then the administrative fees, which is allowing them to be able to bring claims against their counterparts. But the problem with the emergence of third-party funding is that it has the tendency of breaching certain procedural matters related to arbitration, particularly on confidentiality, because as we all know, arbitration is a very confidential process. And so if you have a third party who is not a party to the arbitration agreement funding the arbitration process, normally what we do see is that these funding arrangements do have clauses that require the party being funded to always update the third party funder with information pertaining to the arbitration and the various steps involved in the arbitration. So that is the challenge. Then we have another challenge which borders on ethics, and which is about the conflicts of interest tendencies of tribunals. Because third-party funders may likely have conflict issues with the tribunal, there's the need to regulate the process, because if the tribunal is composed of a seasoned arbitrator who has dealt with these third-party funders in previous matters in his capacity as counsel or anything, the disclosure of these third-party funders would mean that such a tribunal or such an arbitrator would have to recuse themselves. So the trend has been that arbitration institutions have been revising their rules to include provisions that regulate third-party funding. And the ICC, for example, has rules on that, which seeks to require that where a party is being funded, that party must make the necessary disclosure to ensure that the tribunal and the non-funded parties are aware of who the funder is. Other arbitration centers, such as the SIAC and then the HIAC, also have rules regarding third-party funding. Interestingly, the IPA guidelines on conflict of interest also has provision to the effect that for the purposes of determining whether there's a conflict of interest, third-party funders should be treated as parties to the process. So what this would mean is that if a third-party funder is being seen as a party to the process, the tribunal will have to make all the necessary disclosure regarding any potential relationship between the tribunal and then the third-party funder. And I think that this is a very forward-thinking approach. Aside from the regulation of third-party funding by arbitration institutions and centers, there are also regulations by state laws. And in this regard, I think Nigeria is taking the lead in that regard. Section 62 of the Nigeria's recently promulgated Arbitration and Mediation Act requires that a party benefiting from third-party funding arrangement gives notice of the name and address of the third-party funder to the other party, the arbitral tribunal, and the arbitration institution where applicable. So this is what other jurisdictions are doing, other arbitration centers are doing. Presently, under our Arbitration Act, we don't have any regulation on third-party funding. And I don't think that there's any arbitration center in Ghana, the Ghana Arbitration Center, neither the ADR have, where they do have provisions on third-party funding. So the risk is that, there's a potential of breach of confidentiality when the third-party funder is involved and the other parties are not aware of who this third-party funder is. And there's also the risk of a possible breach of conflict of interest, matters. So this is something that we may want to consider. Stakeholders in arbitration in Ghana may want to consider. Either we regulate it at the state level by having a second look at our Alternative Dispute Resolution Act, like the Nigerians have done with their Arbitration Act, or this could be taken on by arbitration institutions in Ghana by revising their rules to cater for regulation on third-party funding. Once third-party funding is regulated, it enhances the integrity of the arbitral process and promotes confidence in the process. I mean, aside from third-party funding, the other trend that we are seeing is the concept of emergency arbitrators. Ordinarily, as we already know, when parties choose arbitration as a dispute resolution mechanism, what they want to do is they want a minimal interference by the courts, like you rightly indicated. And so in this regard, institutions in their rules have empowered arbitration. Institutions in their rules have empowered arbitrators to be able to provide interim reliefs and interim measures to parties when the arbitration is ongoing. But there are instances where even before the constitution of the tribunal, a party would need certain urgent interim reliefs or interim measures. And these are challenges that have led arbitration institutions to come up with rules on emergency arbitrators. So the whole concept of an emergency arbitrator is an arbitrator who is appointed before the constitution of the panel to deal with these interim matters. And this was introduced by the International Center of Dispute Resolution in their 2006 rules. This subsequently caught up with other arbitration institutions like the LCIA and the ICC. Currently, we do not have provisions on emergency arbitration in our Arbitration Act. But we do note that Nigeria, once again, Nigeria making the headway, in their recent Arbitration Act have made provisions for emergency arbitrators. I think when it comes to emergency arbitrators, the Ghana ADR Hub also has rules on that, which caters for it. But there's a challenge with the whole concept of emergency arbitrators because with all the arbitration institutions that have emergency arbitrators in their rules, what happens is that a party cannot seek an ex-parte relief before the emergency arbitrator. And this is particularly due to the concept of due process in arbitration. Because of due process paranoia, tribunals are unwilling to entertain ex-parte applications when it comes to international arbitration or domestic arbitration. So what happens when, before the tribunal is constituted, a party needs an urgent relief, like the freezing of the assets or the bank accounts of the other party, and he still has to bring an application or notice to the other side? I think it makes the whole concept of emergency arbitrators counterproductive, because at the end of the day, you will still have to draw the attention of the other party that you are going after him for an interim relief. And being in the know about this, he will take steps that can jeopardize whatever orders that the tribunal can make. But aside from that challenge, there's also the challenge of the enforceability of the orders of emergency arbitrators. Because as we all know, arbitral awards are enforced in a manner as a judgment of the court. And this is applicable under the New York Convention. So the whole point is that if emergency arbitrators cannot make awards but can only make orders, and this is actually seen in the ICC rules, which provides that the decisions of emergency arbitrators are in the form of orders, which parties undertake to comply. The question is, can you enforce these orders in a manner of a judgment? I mean, that makes it very questionable. And aside from that, another issue is that the orders of emergency arbitrators are not binding on the arbitral tribunal, the substantive arbitral tribunal that will be composed. So what would happen is that emergency arbitrators would make a decision and this can be reviewed. So this has really thrown this issue into doubt as to whether emergency arbitrators are really relevant given the landscape of arbitration. And I would want to ask you, Melissa, as a practitioner from a strategic point of view, if you have a dispute that is subject to arbitration and your client needs an urgent relief, would you rather not want to go to the courts to get an interim relief from the court, particularly an ex parte interim relief, which is within the ambit of the High Court, than to get an order from an emergency arbitrator that is not binding on the substantive tribunal? What is your approach? Which one would you prefer?
Isaac, as a practitioner, I'm mindful of my clients' needs to have their disputes resolved quickly and efficiently. And I'd rather go to the courts for an authoritative order that can be enforced, that has the full backing of the law, and that makes it easy for my client to quickly progress onto the next step of resolving their dispute. So for me personally, I agree with the parties or the position that emergency arbitrators are not necessarily needed where the court has the powers to grant the same sort of relief and which is enforceable.
How about my lord? What's your take on that? Do you have any perspective?
Well, as somebody who is dead against unnecessary intrusion by the courts in arbitration, I will opt for the power being given to the arbitral tribunal to make interim orders regarding such matters. And I think legislative reforms is all that we need. Once we have rules that state that an award given to an arbitrator is now equated to a judgment of the court, legislative reform could equate interim orders made under such emergency arbitration to orders of the court and enforceable in the same manner as orders made by the court. So I'm somebody who is dead against the slightest intervention in arbitration by the courts.
Well, it's quite interesting, the two perspectives that you bring on board, because the Queen Mary University of London in 2015 conducted a survey on this issue, asking respondents which form of interim relief they preferred. And only 29% of the respondents indicated a preference for interim relief from emergency arbitrators, with about 46% showing a preference for the domestic courts. So it appears that disputants or parties are still confident in interim reliefs given by the court as opposed to emergency arbitration. And when you see the factors that influence the decision of the 46% of the respondents, what they did indicate, 79% of the respondents indicated a concern about the enforceability of the reliefs given by emergency arbitrators. So it fits into the fact given by Justice Amegache that maybe if we're able to cater for this through legislative reform, then the enforceability question can be dealt with. So coming back to Ghana, is it time for us to have a reconsideration of the ADR Act to include emergency arbitrators, or should we leave this for arbitration centers in the country to spearhead these reforms? This is a food for thought. The other thing that the other trend that we do see is the arbitrability of environmental disputes. All over the world now, the previous perception that environmental disputes are not arbitrable is long past and gone. I think that when we enacted our Alternative Dispute Resolution Act, one of the commentary that came, and which was from you, my Justice Amegache, was about the issue of the inarbitrability of environmental disputes. Even as of 2011, you were of the view that that was an unfortunate provision because we thought environmental disputes were arbitrable or should be arbitrable. Now it's even gone far ahead because of climate change related disputes and all that. There's significant discussion on the need for arbitrability of environmental disputes. So I think particularly with Ghana, where we have issues regarding our environment in light of this galamsey menace and the disposal of waste and all that, if various stakeholders who are minded to take errands responsible for their action against the environment would want a very swift dispute resolution mechanism. In my view, I think that arbitration would offer that form of dispute resolution mechanism, for which reason there's a need for us to have a look at our provisions on arbitrability in respect of environmental disputes. So these are the trends. I mean, there are so many trends, but for want of time, I would want us to consider the issue of third-party funding, emergency arbitrators, and the arbitrability of environmental disputes.
Yeah.
Thank you very much, Isaac. So what is your take on the future of arbitration in Ghana in light of these trends that you have stated?
Well, I think arbitration has a significant future in this country, given the fact that Ghana has a significant level of infrastructural deficits. What it means is that there's going to be significant infrastructural development in the future. When you look at the political landscape of our country, there's always a promise for infrastructural development. And as we already know, infrastructure comes with issues of arbitration. In the construction industry, there's a seeming preference for arbitration, as with other industries. So given the fact that there's a likelihood to be significant infrastructure development in Ghana in the future, this connotes that arbitration will continue to grow, and it will grow significantly. I also believe that due to the promotion of interregional trade in Ghana as a result of the African continental free trade, that would also enhance the growth of arbitration. And I do note that under the protocol of AFTA, the form of dispute resolution provided there is interstate arbitration. But I believe that at least the whole recognition of arbitration, whether interstate or not, is an indication that there will be an awareness of what arbitration is, and that will spearhead the growth. Again, I do believe that arbitration will grow because of the awareness of arbitration now. As Justice Amegache indicated previously, there wasn't knowledge and training on arbitration under the previous regime. And this is because arbitration had not developed into a subject area that was taught in schools and all that. But we do now have institutions in Ghana teaching arbitration. I think University of Ghana has models on alternative dispute resolution, including arbitration. So there's hope for the future. The local chapter, the Ghana chapter of the Chartered Institute of Arbitrators, is making the efforts to train people on arbitration, and that shows that the future of arbitration is bright. In talking about the future of arbitration, I believe there's a need to mention the need for training of our judges, because if we have a very good judiciary, that will significantly facilitate arbitration. If we have judges that appreciate the basic tenets of arbitration, they will be in a role to play the supportive role and avoid as much intrusion of the process as possible. So these are my thoughts on the future of arbitration in Ghana, Melissa.
Thank you very much, Isaac. That was very insightful. Justice Amegache, I'd like to ask you, considering you commenced your practice sometime in the 1980s and you've seen the developments of arbitration throughout the years, what are your hopes for the future of arbitration in Ghana? Do you align with Isaac's position, or you have some other alternatives?
I think I agree with Isaac. The future of arbitration is bright. More parties and lawyers are now getting to know arbitration. They are being sensitized. We are witnessing more international agreements with arbitration clauses in them, which was not the case in over the last 10 years or so. And with quite a number of investors coming into the country in the construction business, in the mining business, the oil and gas business, most of the agreements, I can say about 90-something% of the agreements all have arbitration clauses in them. And that has called upon the lawyers now to update themselves and educate themselves so that they will also be competitive when it comes to issues relating to arbitration and not just courtroom litigation. So the future of arbitration, I'll say, is very bright. And what we ought to do in order to solidify what we have right now is to set up the center, when you look at the Alternative Dispute Resolution Act, it talks about a center, setting up a center. 13 years down the line, the center has not been set up. So we ought to set up centers equivalent to most of the international centers all over the world. And I'm sure we should position ourselves within the sub-region as a hub for international commercial arbitration.
Thank you very much, Justice Amegache. We have a few questions that have come up. Due to time constraints, we'll each be answering a question. So, Justice Amegache, I have a question from a participant, and the question is, how can I get mentorship in arbitration?
Well, these days, there are several institutions that are training people in arbitration. You have the Chartered Institute of Arbitrators. They have the Nigerian branch that is responsible for training people within the sub-region. And then currently, we have a chapter in Ghana. All their training schedules are online, and you know whether the trainings are taking place in Ghana or Nigeria or in Europe. There is also the London Court of International Arbitration and so many other international arbitrators, arbitration training centers. So, and then the universities, as you said, the University of Ghana and other universities are also now doing quite a lot of training. The most important thing for any person is to accredit himself or herself. And to get the accreditation, you ought to be trained and accredited by some of these international institutions. So it's not difficult to find once you get online and find out their training programs and schedules.
Thank you very much. And there's another question which I'll take, which is, how can ADR be made acceptable and more attractive to litigants? I think it can be made more attractive and acceptable via a wide range of means. First, I believe there has to be public education on the topic of arbitration or other alternative dispute resolution mechanisms. I believe the public needs to know that when it comes to resolving their disputes, they are not bound to just courtroom resolution of that dispute. I also think that judges have a duty to educate litigants about the option afforded to them under the Act to resolve their dispute by arbitration. Along with that, I think lawyers also play a role in this when we are drafting commercial agreements for our clients. I believe that it's incumbent on us to point our clients in the right direction about the method to be adopted to resolve their disputes. If you are drafting an agreement which you believe is quite technical in its nature, can advise your clients to adopt arbitration as a means of resolving their disputes and go as far as specifying the qualifications of the arbitrator that you should use. So those are some ways that I think ADR can be made acceptable and attractive to litigants. I have one last question here, which I'm going to ask Isaac. And the question is, can foreign seated arbitration awards in India be executed in Ghana or enforced?
Yes, I would say that under our Alternative Dispute Resolution Act, the basis for the enforcement and the recognition of foreign awards is when a state is a contracting state of the New York Convention. I believe that India is a contracting state of the New York Convention. And so once an award coming from India is sought to be enforced in Ghana, so long as it satisfies the formal validities under the Act, including providing an original copy of the arbitration award and then the arbitration agreement, that can be enforced. Melissa, I think there are other questions in the chat box.
Yes, I've just seen a question for Justice Amegache. I think it's quite apt given your role in the ICC and representing Ghana on the ICC in The Hague. So the panelist participants has asked, can you give reasons why in most commercial arbitration involving foreign investors and Ghanaian parties, the preferred choice for arbitration usually is Paris or London, and hardly any major arbitration proceedings takes place in Ghana?
It's unfortunate, but I think I will assign two reasons. First reason is our policymakers and those who signed our agreements. They signed the agreements and they agree for the seat of arbitration to either be in Paris or in Europe or US, where and it is not applicable to Ghana alone, but there is a research which shows that Africa pays billions of dollars annually to arbitral institutions, arbitrators, and lawyers representing African countries for arbitration in these countries rather than in Africa. So it's quite unfortunate, but our policymakers must change their position and insist that arbitration can also be conducted here. Secondly, we need to strengthen our institutions that can conduct international arbitration. Our institutions are not equipped, and for Africa to be competitive, they need to set up institutions that are equipped with all the international gadgets and other things so that arbitration can be conducted on the continent of Africa successfully. These are the two reasons I would give because of time.
Thank you very much, Justice Amegache. Dan, I'll hand it back to you.
Thank you very much, Melissa. Just looking at the time, I think that is a fantastic place to wrap up and finish. So thank you very much to our esteemed panel, to Nene, to Melissa, to Isaac for your time and your insights, an incredibly informative hour that we've spent to you. And thank you very much to our audience for the questions that have been sent in today. We really appreciate you being with us. We hope to see our panel again in the future, and we hope to see you again. So have a lovely rest of your day. Goodbye.